Hello everyone, it's Professor Kristl, and this is the second of our video series. And today it's about cases, reading cases and understanding the role that cases play in our study of the law. So the first question we should ask is, well, why do we study cases? What is it about them that makes them so important to learning the law? Well, first, cases are one, though not the only, source of law that we have to deal with as attorneys. You are going to find, as you go through your law school experience, that there are several different sources of law. There are cases, there are statutes, there's the Constitution. Later you'll learn about that there are regulations which exist, all of which can define rules of law. But cases play a central role in all of our understanding and development of the law. Here's why. First, in many areas of the law, there's no other source of law besides judges ruling on issues. So a lot of the fundamental principles of property law, like found property and bailments and things of that nature, arose out of judges deciding questions and cases to apply a rule of law to a particular situation. So, in many cases, case law is the source of law. But even when we're talking about statutes or regulations or the Constitution, cases are the way that the language of those other sources of law get interpreted. What does it mean when a particular statute says what it says? The Constitution, of course, is a great place where, what does the First Amendment mean? What does the Second Amendment mean? We see this language being continually interpreted by judges, all the way up to the Supreme Court. So cases are a very important source of law, whether it's a primary source or a source that interprets what a statute or a regulation or the Constitution might say. So cases are central to what lawyers do. Second, cases are important because they give us insights into how the law develops. When we see a particular rule established by a judge in a particular case, it's amazing how often now the legislature then passes a law to sort of undo that effect. In effect, overrule the judicial ruling. All right? So sometimes it drives the development of statutory or other law. Regulations often reflect the impact that judicial rulings have made on previous versions of the regulations, or on what a statute said, and therefore the regulations are designed to reflect that judicial interpretation. So, case law gives us insights into how the law develops. Why did a judge adopt a particular rule in a case? We get to understand that a little bit better. Just as important, cases give us insights into judges and litigants. Now, that may not be important to you as a law student, but it becomes very important to you as a practitioner, right? I've just been assigned a case to Judge Smith. How has Judge Smith ruled before? By reading cases, I can see how Judge Smith has dealt with similar kinds of cases, and therefore get a sense of how he might rule in my case. Right? And finally, cases can give us some insights into practice. What is it we need to do in order to advance our client's claims in a court of law? And so let's explore these different areas to see how cases can help us learn. All right, so if we look at it, we say, okay, well, how can cases help us learn? Well, as I suggested, first, they can help us understand what the law is. Second, they can help us to understand facts. Not just the facts of a particular case, but how those facts are impacting a particular ruling in a case, so that we have a better understanding of what facts are important for a particular rule of law. And then, as I said before, cases can help us learn about practice. So let's talk about these. All right, first, cases and the law. Well, obviously, one of the things that cases do is they tell us the rule. That, in this particular situation, the court finds that there are 4 elements to a copyright claim. And this is how it applies in a particular situation. Right? The rule when property is found. Is this mislaid? Is this lost? Those kinds of rules. Okay? It tells us the rule. Just as important sometimes is it tells us the policies behind the rule. Why did the court rule the way it did? And what we're going to see as we read our cases is that sometimes the courts explain why the rule needs to be this way. That somehow particular groups of people are benefited by this rule, or the old rule needs to be rejected because it fails to take into account a new important interest. So it shows us policies and reasons as to why the rule being adopted is the one being adopted. So it helps us to understand that. Well, why is that important? Well, a lot of times, by understanding the policies behind the rule, we are now developing potential arguments that might help us if, in our case, we have to defend the rule. Because if the policy says, well, we need to protect a certain group of individuals, then the argument might be, well, Judge, rule in my favor because this will help meet that policy. It helps protect that particular group that was recognized in the case law. Or if I want to overturn a rule, I might argue, well, look, the policy behind that rule is no longer relevant. For example, we're going to see when we study landlord-tenant law that much of the early landlord-tenant law was developed at a time when a tenant was someone who was renting land to farm. They were a jack of all trades. They were expected to be able to fix everything that was on the property. And so the expectations about what a tenant can do and what a landlord needed to do are very different than they are in the modern world, where we don't know how to fix things. We hire people to do it. We have different expectations about what we want the property to be able to do for us. So those kinds of policy bases can help us understand and support arguments that we might want to raise in our particular case. And also, related to that is, cases can show us why rules change. We're going to read cases where the fact that we are no longer an agrarian or farming rural society, which was the assumption behind the early landlord-tenant rules, means that we need to have a different set of rules now. All right? So it can help us show those changes. How about facts? What can cases tell us about facts? Well, first, of course, they can tell us the story behind a case. How did this case arise? What happened between plaintiff and defendant that ultimately ends up in a courtroom? That can help us perhaps to get some insights into what leads to litigation, and that might also help us to understand sometimes where our client is coming from when our client wants to litigate. So it can help us to sort of understand why certain things happen and the story of the case and how it led to that litigation can help us to understand. Second, of course, facts allow us to see the rule at work. If the rule is you need to have these 4 elements, and the facts are that elements 1, 2, and 4 are present but 3 is not, well, that shows us that, hey, you don't have all the elements present, you have failed to establish the cause of action. So it allows us to see a rule at work in a very concrete context, because here are these people who have this particular set of facts, and now we see whether or not the claim is valid. And also, facts that come out of a case can help us explore how the rule can change or how the results might change. For example, if we change the facts in a hypothetical, will the results still be the same? And if so, why? And if not, why not? So, the facts that arise in a case can help us to understand and learn how the law works. Finally, cases in practice. Well, how can cases help us understand practice issues? Well, first, as I said before, cases help us see how legal disputes arise, right? So we have a better understanding and maybe some sympathy when our client walks in the door, because we've read about cases where, a person who is suffering this kind of wrong decides to litigate. So it can help us understand how the legal disputes arise, maybe why they arise, and that might help us prepare for dealing with the real clients we're going to have to deal with in practice. Okay? Just as important, cases show us how those disputes get adjudicated. Right? This is where civil procedure really starts to help us understand the case that we're before. In your civil procedure class, you're going to learn things about like how a motion to dismiss operates. What's the standard of law that a court needs to apply when it's trying to decide a motion to dismiss? Motion for summary judgment, different way of getting to a decision, different set of standards. Right? A trial, different way of getting there. But understanding the procedural posture of a case helps us to see how those civil procedure rules work in practice. Or if we're talking about a criminal case, how the criminal procedure rules work in practice. So it allows us to see how these cases get adjudicated and to understand, get an insight into the procedures that drive a case to the decision that we're reading for class. But cases can also help us understand what we're going to do in practice by showing us how arguments are made. Given this set of facts, the plaintiff decided to make certain arguments, to raise certain legal issues. So we get to see how those arguments are made, and we also get to see whether or not the arguments work. How are those arguments interpreted by the court? Were they accepted? Were they rejected? Why? It helps us to learn some of those analytical and argument skills by seeing what worked and what didn't, and trying to understand why something worked or didn't work. Right? So, cases help us to learn how to practice law because we get to sort of examine how somebody else did it and to see whether or not it succeeded or not.